Good afternoon and welcome to our second September webinar, a fireside chat with outgoing NASAA President Claire McHenry. Before launching into today's introductions, I have just a few housekeeping items for everyone. We would ask that you mute your microphones and turn off your videos so that the focus stays on our speakers. This webinar is 1 hour in length. It is being recorded, and within the next week, you're going to receive a link to the recording and a post-webinar survey that we would really appreciate you completing. We ask that you put your questions in the chat box. We will be monitoring those and posing them to our speakers on your behalf. We will answer as many of the questions as we can in the time we have available. We have two guests presenting our third annual Fireside Chat this afternoon. Claire McHenry is a Deputy Director, Securities Bureau, Nebraska Department of Banking and Finance. Ms. McHenry has 20 years of state securities regulation experience. She's an active member of NASAA and has served as the NASAA President for the 2023-2024 term. She earned her Bachelor of Science in Business Administration from Washington University in St. Louis and a Juris Doctorate from American University, Washington College of Law. We also have Margie Weber, Reg Ed's Director of Regulatory Compliance, who will be hosting today's discussion. Before joining Reg Ed in 2010, Margie spent 25 years in various financial services, compliance registration related positions. Margie served as the president of SILA from 2007 to 2009, served for several years as SILA's governance chair. She's been a member of SILA's advisory board and the recipient of SILA awards in 2002, 2003, and 2010. She also has served on FINRA's Licensing and Registration Council, Registration and Qualifications Subcommittee, and currently serves on SILA's Securities Industry Subgroup Steering Committee, and also moderates the SILA NASAA State Engagement Task Group. So please join me in welcoming both Claire McHenry and Margie Weber to our virtual webinar stage.
Thanks, Julie. We're so happy you guys are joining us today. Okay, get it out of the way. So Claire, congratulations on the end of your first year of being a SILA president, or NASAA president. I'm sorry, we were just talking about being SILA president earlier. So congratulations. I hope this isn't your first and only term, but.
Well, thank you so much. I appreciate so much for the invitation and for being here. And I don't know if it'll be my last term. It's definitely my first term. I can understand why people may want to do it twice, but not 3 times like Joe Borg did.
You don't want to break the Borg record. Some of our attendees may not even be aware of NASAA. Could you give us an overview, please, of NASAA?
Sure. So we're not the space agency, of course. We are the North American Securities Administrators Association. We were founded in 1919, and we're a membership organization of state, provincial, and territorial securities regulators across the United States, Canada, and Mexico. Of course, our mission is investor protection, and we do this through investor education, training for our membership, facilitating cooperation, establishing model rules and statutes, and issuing guidance and advocacy on behalf of our members. And we're made up of a board of directors, the 3 presidential officers, and 6 other board members. And we operate on corporation finance, broker-dealer, investment advisor, enforcement, and investor education issues. Those are our sections. And then we also have a number of board-level committees that look at specific topics like seniors. And I would just encourage anybody to go and look at the NASAA website. That's NASAA, NASAA.org for more information.
Thank you for that. What's your next step with NASAA? You're obviously the immediate past president. What else are you doing?
So as a past president, I'm still a member of the board, and I'm still very committed to the issues and topics that are important to our NASAA membership. You know, as Leslie described in her fireside chat when she became president, we're interested very much in digital assets, building on our efforts to fight financial exploitation of older investors and taking a close look at how the data that we have access to can help us in our regulatory obligations and how we can improve our oversight. So these are all things that still interest me very much, and I'm going to be committed to going forward.
Wonderful. We wish as an industry we had some exposure to the BDIA committees. We're nosy. We want to know what's going on, what's being talked about. You guys kind of keep everything kind of quiet until you hit us with it. So let's switch to our specific topics we're going to talk today. So IARCE, it's a topic everybody's scrambling with. So anything new in Nebraska on that front?
Well, there are now 21 jurisdictions that have adopted IARC. I'm very proud to say that Nebraska very recently had its rules adopted, and so that new requirement will go into effect January 1st, 2025. We're joining New Jersey and the U.S. Virgin Islands and becoming effective in 2025. We're also coming up on some states who have now had it in effect for a couple of years at this point, which means that if you're in one of those states that have had it since 2023 and you have not yet completed your IARCE requirement, you may be at risk of losing your registration at renewal time. So I would just remind those people that it's important to implement and take those IARCE courses, get them put into FINRA, especially before the December 26th shutdown date, and make sure that you have a smooth transition when it comes to your renewals.
Right, that's a very good point. With the December 26th shutdown that's coming.
Mhm.
So the NASAA program, the Investment Advisor Representative Continuing Education Program, is that's what IARCE is. It's the NASA program that each states adopt. It's a model that states adopt. It allows for you to be deficient your CE by 1 year. So there could be individuals right now that have not satisfied their 2023 requirement or their 2024 requirement. So especially for those folks that are deficient in their 2023, that December 26th date is very critical. You can continue to take courses after the shutdown, and your CE providers can continue to credit those courses, roster those courses with FINRA, but your CE status will not be able to be updated during the shutdown period. So you'll go into January of 2025 deficient. And so if you lose registrations because you didn't satisfy your 2023, at a minimum 2023 requirement before the shutdown, you're going to face some consequences. You'll no longer be permitted to conduct advisory business in a state or a jurisdiction that has terminated you. Any adopting state that you are registered in will terminate you for failure to satisfy your 2023 requirement. You're going to have to, God forbid, one of those states is your resident state, because then you're completely shut down. You can't do any advisory business at all. So it's very, very critical that people get their arms around this. Let's see here.
I think I would just really emphasize that too. The IARCE requirement is based on the jurisdictions in which you're registered and not necessarily just your home state. So if you are registered with a state that has an IARCE requirement, you are required to complete your continuing education. And if that does happen to be also your home state, you may be at risk of not being able to conduct business at all if you fail to complete your IARCE.
Right. And there's some confusion in the industry, because you could have held a registration, let's say in Minnesota, one of the early adopting states, or Wisconsin, and then that's what triggered you to meet this requirement. Now, let's say you drop those registrations, you're no longer registered in an adopting state. That requirement sticks with you. You still have to take it year after year, even if you're no longer registered in those states. So that's something that's kind of unique to the NASAA program that you don't see, for example, with insurance CE. If you're no longer registered or licensed in a state for insurance, you don't need to take their CE requirement. So it's really kind of a little tricky and a little different than what a lot of folks are accustomed to. And then if you were ultimately administratively terminated, you're going to have to pay to get re-registered after you make up your CE credits. You're going to have to file a new Form U4 amendment. You potentially, all of your clients that you have reporting to you may have been temporarily reassigned to another investment advisor rep so that it can continue to be serviced. Once you're re-registered, then they need to be moved back to you, which is not going to be a real good look for you with your clients. So it's really a touchy subject, and people really need to get their arms around it. And I haven't heard of any broker dealers or any investment advisors or any states actually like issuing discipline on anybody, but I would suspect, especially with your investment advisory firm, they're left holding the bag on shuffling all your clients around to make sure that they're serviced, that they're not going to like that. So potentially you could face some discipline from your firm, potentially. So that's something to really get your arms around, folks. We promise you that's going to be a problem for you.
And NASAA's trying to be helpful on this. So there are a bunch of resources, including frequently asked questions on the NASA website. Just go to NASA.org and then look under the IARCE resources link for more information about that.
They have great FAQs out there. And if you're a provider, like we're a provider, Reg Ed is a provider of IARCE, and we're encouraging our clients, try to get it all done by mid-December. That allows you to take the course, for us to roster the course, to potentially troubleshoot any technology issues that might have come up, and to get your CE status updated to show that you've satisfied the requirement prior to December 26th. So everybody needs to kind of really get your arms around that. Anything else on IRCE you think we need to highlight?
Well, there's a question about best practices around who does and does not need to do it. It is based on your investment advisor representative registration. So that's going to be the triggering event. Whether or not your company just requires everyone to do it, I'd say it would have to be a business decision up to the company.
Right. And I haven't heard of anybody forcing their investment advisor reps who are not exposed to the requirement yet to take the courses. And I would almost caution against it if firms are considering that, because you cannot repeat a course. So any course you take now, and if you take an IARCE course now and you're not really required to take it, perhaps you're doing it through Firm Element or just additional firm training, that can't be credited to your IARCE for 5 years. Because so for example, if you take a course this year and you don't really need to, you're not required to take it, you cannot repeat that course. Let's use Nebraska as an example. If you're a resident of Nebraska, starting in January, you're going to have a 2024 requirement. Any course you took in 2024 wouldn't count. You can't carry it over, and you can't retake it for 5 years until the course has been, a whole new application has been filed with FINRA and their vendor, and you get a whole new course number. So it's one of those kind of touchy things. Yeah, it'd be great to get that additional training, but you do kind of, you might run into some problems. It would make me angry if I took a course and I couldn't. If I took it in January or in December, for example, just because I wanted to get some extra training, and then I become ready, well, I need to meet the requirement in 2024 and I can't leverage that course. So be careful about that. There's another question here. Can I get an explanation of what IRC is? I think that is IARCE. That's probably, we kind of are running it together. So it is Investment Advisor Representative Continuing Education. So
IARCE. It's an acronym I've stumbled over all year.
It's a mouthful. It really is. So hopefully that answered your question, Rebecca. If it did not, just chime back in. Why don't we switch gears to the EVEP and MQP state adoption? Anything new in Nebraska there?
So in Nebraska, we also just recently adopted the EVEP for both agents and investment advisor representatives. FINRA has its Maintaining Qualifications Program, or MQP, but states have their own exam qualification requirements for registration for both investment advisor reps and agents. Currently, the EVEP adoption for states is 8 states have adopted agent EVEP, and then 7 states have adopted investment advisor EVEP. And that's exam verification, exam validity extension program. Yeah. We love our acronyms, don't we? So if you're seeking registration with a state that does not currently participate in EVEP, your exam extensions that you're using under MQP may not be recognized in that jurisdiction, even if you've otherwise complied with FINRA's MQP. I'll just let you know that states are working hard to start adopting EVEP. However, these exam requirements are written into our rules, and we do have to go through an administrative process in order to change that. And so that does take states time. So just to be aware that you may be in a state where your home state has not adopted EVEP, and you may be wondering, I'm leaving the industry and I'm signing up for MQP. Should I still sign up for EVEP? And this is ultimately still a decision up to you, but I would just let you know that if you meet all the eligibility requirements to join EVEP, you can still enroll even though your home state hasn't yet adopted the rule. And that way, if your jurisdiction does happen to eventually adopt EVEP and you're enrolled in it, then the jurisdiction will recognize that validity of your extension. The thing that I would point out, though, is that just because you've signed up for MQP, that doesn't mean that you've signed up for EVEP or that it will automatically qualify you for EVEP. Again,
And
there's a lot more information about this. I'd suggest going to NASA.org.
right. They have great information on the website. And just for those that aren't aware, so the MQP and the EVEP programs allow you to leave the industry for up to 5 years and return without being required to requalify for exam, assuming you've met the conditions of those programs, which is one of them being IARCE. So back to that.
And just while we're on the topic of exams, I'd be totally remiss if I didn't let your members know that we also have exam guides, NASA exam guides for the Series 63, 65, and 66. These are free resources to people looking to take those exams. They're open to the public and they can also be found on our NASA website under the exams tab.
Perfect. Thank you for that. Let's see here. Residential supervisory locations. So there's a lot of uniformity in the securities world compared to what you see in the insurance space. However, there's enough non-uniform issues to create some challenges for broker dealers, and I think branch is one of those things. And the residential supervisory location, it's a new FINRA rule that allows you to perform supervisory functions from your private residence without requiring that resident to be an OSJ or an office of supervisory jurisdiction. If you meet certain conditions, there's conditions to qualifying for a residential supervisory for your residence location to be designated as a residential supervisory location. So I'm going to use the acronym of RSL now because there's too many words there. It's a particular hot topic right now for industry. And I think we need to talk again about that December 26th shutdown, that once the system shuts down, you're not going to be able to file any Form U4 amendments. So prior to December 26th, broker dealers need to evaluate all of the offices of employment that they have that are located in private residences, and determine if that location qualifies to be designated as a residential supervisory location or an RSL. There's a lot of caveats here. You've got to, in addition to FINRA, you've got states that you have to deal with too. So or other jurisdictions, not just states, Virgin Islands, Puerto Rico, things like that. So prior to the shutdown, any office of employment that is located at a residence location, you'll need to amend that person's Form U4 to indicate, yes, that location is it is a private residence. And 2, are you designating it as a residential supervisory location or not? If they qualify for a residential supervisory location, then you are able to perform from that location supervisory functions that would typically have been done in an OSJ. But the RSLs are being considered non-branch locations, which would make them, you would not require an annual inspection. You would need a cycle inspection, a periodic inspection, presumed to be once every 3 years for those residential supervisory locations. So that's great, from a FINRA perspective, but by my count, there's 11 states that are not accepting RSL, and that also include a registration or a notice filing requirement. So in addition to these Forms U4 that you may need to be filing for your offices that are located in private residences, you may also have Form BR filings that need to be done. For example, if you have, let me see, one of the states let me get my notes here. I'm going to quickly list off the 11 states because that's probably going to be a question that's going to pop up. So I'm going to try to read it pretty slow. Alaska. These are offices that are not currently accepting RSL, and they have either a registration or a notice filing requirement. So that would be Alaska, Florida, Nevada, New Hampshire, New Mexico, South Dakota, Texas, Vermont, the U.S. Virgin Islands, Washington, and West Virginia. So in those states, you're going to have the Form U4 requirement that you need to comply with the FINRA side, but you're also going to have a Form BR requirement to deselect FINRA and either notice file them or register them in these states. So all that also has to be done by December 29th or by December 26th shutdown. So if you need help, holler. We're getting a lot of questions, and there are some outstanding questions as well on that issue because, for example, if you've got non-registered fingerprint persons who are performing back office type functions from their private residences, do you file a Form U4 amendment? I don't think so. I don't know. I think it would be, I don't know if the form NRF would be filed, but you may also need to do a branch filing in those 11 states for non-registered fingerprint persons. I don't know. I'm trying to confirm that. I haven't received any feedback to my outreach yet. So that's more to come on that. And we'll try to publish some updates on that through SILA and through LinkedIn and, whatever. But there are Form BR and Form U4 filings that have to be done before the shutdown. So if you haven't already started thinking about that, first step is, where are all my people sitting? Where do they sit? If it's predictable and routine, that they work from their office 3 days a week and from their home 2 days a week, that's predictable and routine. So you need to identify those locations, determine if they're RSLs, identify the state jurisdictions, the state or the jurisdiction that they're in, and meet those requirements as well. So it can be a little bit complex. So now Claire is living in Nebraska. She's an easy state. Why are you so easy, Claire?
Well, yeah, I mean, this has been an issue. We have several members who have a registration and notice filing requirement. I think that's an important thing to remember, is that the RSL requirement is a FINRA requirement, but some states do have their own separate state branch office registration or notice filing requirement, which can also include an on-site examination portion of it. And that's the question of, are states following RSL? I would point you to the FINRA SRO jurisdiction fee and setting schedule that very clearly identifies what states are doing. So if you need a resource for that, it'll identify whether the state has a branch office requirement, either to notice file or to register, whether it accepts RSL, or if you're like me in Nebraska, whether or not you do not register or notice file branch offices in any respect. So there are quite a few states that don't. I know that there was some confusion in the industry about whether or not states like me accepted RSL, but that form was recently updated on September 10th. So if it's something that you've looked at before but haven't recently, I encourage you to go back and look at it again, because I think that's going to be your best bet to identify clearly which states have a registration requirement and whether or not they accept RSL. This has been an issue that's been of great importance to NASAA. That's why we had so many comments on FINRA's rulemaking, and we were really pleased that they accepted so many of our comments, especially about eligibility conditions, risk assessment criteria, some other considerations. And we'll be looking and being very interested in how FINRA is going to be implementing this pilot program.
Thank you for that. I think that was one of the best edits we've seen made to that fee setting schedule in a while. So it's really good. It's very, very clear. Don't forget, there's a legend down at the very bottom of that for you all that basically defines, yes, if it's yes, it means this. If it's no, it means that. If it's NA, it means this. If there's a dash, it means that. So just follow that. We do have a question on this. That's our jurisdiction schedule is sometimes cached in a user browser. Be sure to clear the cache to get the most recent version. Okay. I haven't experienced that problem. Thank you, Anna or Anne.
Mhm.
All right, anything else on branch registration, notice filing, non-notice filing? I think we covered it. Branch inspections is a requirement of states in addition to broker or FINRA, so you got to be concerned about that. For example, some broker dealers right now are participating in the remote inspection pilot that allows you to remotely inspect your branch locations. Some states may not accept that. So you need to be, sometimes the state jurisdictions are an afterthought in our processes, but we need to make sure every time you're considering a compliance issue, you really have to look to the state as well.
I
One
agree
thing
with
that,
that and just say,
yes,
if you're in a state that does have a state branch registration or notice filing requirement, go ahead and just reach out to that state to see if they do have an on-site portion of that examination requirement.
right. One thing that I've talked, this is like we said at the beginning of the session, this is the third annual Fireside Chat with the outgoing NASAA President, and we with Melanie and Andrew the past 2 years, fraud was one of the topics that we discussed, and it continues to be a hot topic for NASA. By my count, there were at least 78 investor alerts or consumer alerts or education pieces that were published by federal and state securities regulators since while you were in office for the year you were serving as president. So the regulators are highly focused on fraud. So you want to speak a little bit to that?
Sure. So, seniors absolutely continues to be a focus of our enforcement efforts. The NASA Model Act has been enacted in over 40 jurisdictions at this point, and we continue to see internet and social media frauds, digital assets, and promissory notes and precious metals as being high-ranking types of products that are involved with our older investors. I would just encourage you to continue to report those to your state securities regulators and adult protective services. And I really do encourage you to keep the state securities regulator involved in that process. Oftentimes, I find myself being the translator between our industry and our adult protective services, going both ways, just to make sure that everyone understands each other. Not everybody can speak APS and not everybody can speak finance in some respects. So I would just encourage you to make those reports. I know some states have a mandatory reporting requirement and some states have a voluntary reporting requirement. Just please go ahead and make those reports. A big issue that continues to happen for us is the issue of digital assets and cryptocurrency. This continues to be at the forefront, and we continue to be at the forefront of protecting investors involving these types of digital assets. We're seeing a significant increase in the number of complaints and investigations that are involving digital assets, which can be really complex and very difficult to investigate and can evolve very quickly. These investigations take a lot of work. So I always take a huge amount of respect and appreciation to our investigators who are looking at this. If you have were aware of our annual conference, you may have heard that we had a recent multi-state effort involving a digital asset company called GS Partners, a working group of states. It had a multi-million-dollar settlement with GSB Gold Standard Corporation, and that's a company based in Germany that purportedly operated a fintech and banking in the banking industry. And they're most commonly known as GS Partners, but it also was against Joseph Haidt, who was a principal and chairman of the board for GS Partners. The lead states were Alabama, Arizona, Arkansas, California, Georgia, Kentucky, Mississippi, New Hampshire, Texas, Utah, Washington, and Wisconsin. But this was also an act that was international in scope. We had our Canadian regulators that were also involved in this multi-state action. They just incredible work done by these working groups. They pooled their resources, they leveraged their expertise to quickly investigate the respondents and their offering of investments tied to digital assets in the metaverse. And they were able to secure a term sheet that would return the investments to investors and also appoint a receiver in order to administer that return of investments. The other big issue, and if you were listening in on our NASA annual conference, is pig butchering, which is very closely tied to cryptocurrencies. That's not a term that I particularly like. It's unfortunately a term that is frequently used, but you may have also heard them as relationship scams or confidence scams. And that's a lot going into it. I'm happy to dive further into what pig butchering is, for those who may not be familiar with it.
I think if you guys have questions about that, put it in the chat. I think it's important for investors to understand that the state regulators are available to them. I feel like, especially with the older investors who are victims of fraud, a lot of times they're too embarrassed to bring it to anybody's attention. And the longer you go without bringing it to someone's attention, then you can't you don't have you're kind of hamstrung. There's not a lot of ways you can help them get their monies back. So this scam that you were just talking about, it's lovely to hear that you were able to get the investors' money returned.
Yes.
That's not something that's real common.
I do see a question of they don't know what pig butchering is. So it's been called also a relationship scam or a confidence scam. It may go by some of those names, but pig butchering does happen to be the most commonly used term for it. It's where the scammer is seeking targets online through social media platforms. And this can be anything from your professional LinkedIn type of social media to dating websites to messaging apps. Or Facebook, or it can even be through like those wrong number text messages trying to get a hold of you. They're going to pretty much use any way that they can to get a hook into you. And what they're going to do is slowly build trust. And this is part of the big part of the pig butchering scam, is they really do take their time and effort to build that trust with you. And they're willing to engage with you for weeks to months at a time in order to build that trust. And that's where the relationship portion of it really begins. And it can be anything. It can be through a friendship. It can be through a business promotion. It can be romantic. But basically, they're going to create a fake identity and fake personality in order to gain your trust. But once they get your trust, they're going to convince you to invest money, often through cryptocurrency. And they may offer advice on trading or claim to know about profitable opportunities. They may even indicate that they know someone or a financial advisor who has, the best trading out there, who can make you a lot of money. And they'll often start small and then start asking for even larger amounts. And that's where the slaughter portion comes in. What we found with these pig butchering schemes, though, is that they're often coming from overseas and coming from highly organized criminal organizations that are targeting our middle class and it's often senior investors. And what we see is it's difficult to penetrate that level of trust that's been built, but these can be quite devastating for people. And someone who you would never think would open a crypto wallet in their entire life are being walked through how to open a crypto wallet and transfer that money overseas.
Wow, that's disgusting. It makes me so mad. It ties, a little bit. Broker dealers need to be very, very investment advisors as well need to be very, very cautious to be looking out for these kind of. They need to understand it so that they can look out and protect their investors. So, what is the trusted contact, and why is that so important?
So the trusted contact is a requirement for the firms to request, but not necessarily obtain, a trusted contact on their brokerage accounts and for their clients. And it is not the same as giving somebody a power of attorney over an account. They don't have the ability to make decisions on that account, but it is the ability to have someone that you can reach out to if you have questions about something that is going on with your client that they have said that you can reach out to. That is something that you should ask for every client, regardless of age of the client, and you need to be making a reasonable effort in order to do so. These trusted contacts are so important. They really are useful in getting people help when we need to. And they work quite well with the report and hold laws that are with FINRA and with the states, because when we enter a situation where we think somebody might be vulnerable or being currently exploited, we want to have somebody that we can reach out to, and that trusted contact is there. FINRA and the SEC and NASA has a lot of great resources on this, and for those clients who may not have you may not be sure about providing a trusted contact, we do have a short video that helps explain what that trusted contact is that may be helpful.
And can you describe the report and hold options
So,
that you just mentioned?
sure, the report and hold options. So FINRA has a report and hold requirement, but the states also have their own NASA Model Act report and hold requirements. And that is to allow and give tools to our firms to basically, when they suspect that there is elder financial exploitation or financial exploitation of an older or vulnerable adult, that they can actually hold that transaction and not disperse those funds out to the client. And then, but if they do so, they have to also notify the state securities regulator and also notify Adult Protective Services. The other thing that allows them to do is to also notify certain parties, third parties involved in that transaction, so they can potentially get help for that person. And when they comply with this law, they're given qualified immunity in order to make those types of contacts. And so that they're not in violation of Gramm-Leach-Bliley or the Bank Secrecy Act, that they can in fact make those types of contacts to those persons. Now, the NASA Model Act is there, and I would encourage you to go to the NASA.org to take a look at it, because there's a lot of available resources to firms on how to implement that, including a implementation guide for small firms. And investment advisors that I've heard is very useful in setting up a compliance program around the report and hold laws. But some states are a little bit different in how they implemented it. Some have a mandatory requirement, some have a voluntary requirement. Even before Nebraska had it, firms were reporting to us, and we found that extraordinarily helpful. In fact, people ask if they work, and I can give you a resounding yes, they absolutely do work. Within a few months of implementing our act in Nebraska, we had a report of somebody who was concerned about one of their clients. I wouldn't have described it as pig butchering at the time, but I now know that it probably was pig butchering at that. But they had lost almost $750,000 from their account based on the initial investments and all the fees and taxes that they were told that they needed to pay in order to get their money back. But based on that report, we were able to issue a cease and desist and take down that website, and also convince the person to stop sending more money out on this scam. So they absolutely do work. I know it can be difficult and frustrating to make reports, and you think they may not go anywhere, but there's a lot of resources out there to help you and make good reports to these regulators.
And those report and hold rules, they would, I mean, even if the investor doesn't qualify as a senior investor or a particularly vulnerable person, if you're detecting fraud or suspicious activity you believe that could be.
So it is specific to older or vulnerable adults, and that vulnerable adult may differ from state to state based on that interpretation. But if the thing is that if you have any question about whether or not the person is vulnerable, if they meet the qualifications of that, you don't have to make that determination. You can go ahead and make that report to the state securities regulator and Adult Protective Services. They're going to tell you whether or not they're going to accept the report, the referral, open an investigation. And so it's not on you as the firm to determine whether or not they have capacity or they're a vulnerable person. If you have a reasonable suspicion that someone is being exploited, go ahead and make that referral.
Thank you for that. You've mentioned a couple of times model acts. Can you describe let the folks, some folks may not know what a model act is and what that means.
One of the things that NASA does is it provides, subject matter expertise and guidance to industry. And another important function that it has is that it adopts model rules and statements of policy and statutes for its members, so that they can use that model language in their own statutes. So even though NASA has issued a model act or a statute or rule or statement of policy, it's still on the particular state to actually adopt and implement that particular model act. But it's based on the expertise of our members and what they're seeing out on the ground.
Perfect. Thank you. The NASA enforcement report for 2023, using 2023's data, it had some fee. You had meant when we were talking last week, you had mentioned concerns around the types of fees that are being charged. You want to talk a little bit about that?
Sure. So that was actually something we saw in the most recent investment advisor report. It's a great report. It just came out at the NASAA Fall Conference. And I just would love to highlight some of the good work that they do. It's a great report that highlights, statistical information about the state registered investment advisors population and the profile of our average state IA, as well as the work of the IA section. And a couple of those things I would highlight are the cybersecurity efforts. This is the security of our firms and the clients and their data is a priority for us. Cybersecurity, we have training for our examiners. We have a model rule regarding cybersecurity, and we also have resources for firms about how to do an inventory, the types of checklists that they may need to consider when they're implementing a cybersecurity program. The other thing that I would highlight from that is relating to fees. One of the interesting things I saw that came out of that report is most firms have their traditional fees, the assets under management, the fixed fee or the flat fee that they have, but a surprising number of alternative fees. They were described as other, and 14% was listed as other, which seems pretty darn high to me. NASAA, this is something that we've been seeing for a little while now, especially at the state IA level. Advisors really experimenting with the types of fees that they offer. And NASAA has actually issued guidance on how it reviews fees. And basically, it all just boils down to fees need to be reasonable given the services that are provided. And this is something that comes up during our examinations. It comes up during our registration process. But basically, we look very closely at fees because this is a huge factor of why somebody is deciding to go with a particular advisor. And so we need to have clear disclosures about what they're doing, a clear understanding of why and how they're charging that fee. And so I just really recommend that people go to the NASAA website and look up that guidance and see that you can see what the thought process is on it. We have a lot of questions because these are newer fees. I know that sometimes I've asked questions and people have interpreted it as, oh, I must not like that fee. Mostly what I'm trying to understand is just understanding the fee. I want to know how it works and the benefit that the client gets from it. So there's a lot of good guidance there, particularly around subscription fees, alternative bases for charging it like a net income or a net worth standard as opposed to an asset under management standard. There's a lot of good guidance there. And really, it does just boil down to charge a reasonable fee.
Right. Be able to explain what you're doing too.
Exactly.
I think that ties a little bit to artificial intelligence and technology that, there's, when I first started, I'm dating myself, when I started in the industry, we had typewriters. We would roll the E4 into the typewriter and key that information in. So, ever since 1985, when I started in the industry, it's been technology development over. It just has never stopped. It's just a cycle that continues to. So now we're seeing artificial intelligence, machine learning, large language models. There's a lot. And, the regulators are interested in that. I know that on the SEC's agenda, they're targeted to potentially re-release their predictive data analytics proposal sometime in October, potentially, if they do that. So it's interesting. I'm not sure if NASA has anything. I know you did support
as I mentioned in my inaugural remarks, when I became NASAA president, I had reflected on how technology has really driven almost every aspect of the client and financial advisor relationship. And innovation is absolutely essential to the success of our capital markets. But it's also equally important that as we innovate and look at these new technologies, that we keep the investors top of mind. When it comes to artificial intelligence, we're really kind of seeing three different things. There's from the enforcement perspective, we're seeing something that has been called AI washing, and that's when people are using terms related to AI and basically making claims that they have AI in their programs or that they can, trade or make money using AI programs that they really don't have, that they're making claims about the use of AI in their systems that they just are not able to support. And or they'll tout that because they use AI, it's safer or more reliable than other types of programs. So we really see that type of AI washing, and we're already seeing cases and complaints involving that. Including in Nebraska. The other aspect of AI that we are seeing is the use of AI to make more traditional scams more believable. This is the use of a face filter or a voice modulator to make somebody's voice sounds like something that you're more familiar with. The creation of scripts using ChatGPT, using fake images in order to make our more traditional scams more believable. And that's like if you were to take a grandparent scam, but have your grandchild have a video call with you with a face filter of somebody from an image that they pulled off a social media website using the voice of the grandchild from a TikTok that they pulled and a ChatGPT script to make it sound like their age and cohort. So it would just make traditional scams harder to find. But the other aspect that we see with AI, I think, is just AI is a tool. It is a really interesting tool that is out there. And we're already seeing how it's impacting us. But because it's a tool, it's all in how we use it. It really, I think, presents some really interesting opportunities for us as an industry. It allows us better methods to analyze information. It can improve our customer service experiences. It can make our traditional processes more efficient. We can, even have it make it easier for investors to receive investment advice using AI. But we also have to weigh the risks and challenges that come with it. So how do you supervise alternative or AI? How do you ensure that the recommendations are in the best interest of the client? How do you accurately and adequately disclose how you're using AI and how it's reaching those decisions? And I think our job as regulators is it needs to be our responsibility to make sure that broker dealers and investment advisors are compliant with the regulations and policies that are in place, and that we must think about the risks that AI and machine learning pose as we go forward.
Right.
But I think it's a really fascinating tool. I think there's a lot of ways that can be used, but we just need to be very thoughtful about how we're using it.
It should be interesting what we look like 10 years down the road. You know what I mean? It's going to be totally different industry. So I just want to remind the attendees there are opportunities to provide questions in the chat, so feel free to do that. If we have any regulators on the call, which I know that we do, if any of you guys want to jump in and chat with us, please do. I believe you can unmute yourself. If I'm wrong, sorry. So let's see here. What keeps the state regulator up at night?
Right now, a lot of it is having to deal with digital assets and all artificial intelligence. It's definitely one that is keeping us up at night. NASAA has been very engaged in digital assets and cryptocurrency. We're very close to our constituents, and the types of complaints that we're seeing are involving social media and cryptocurrency. And we're really focused in on efforts to make sure that we can retain the authority that we need in order to do the job that needs to be done. And so we're very close in keeping an eye on activities that are happening on the Hill and also in our state legislatures to make sure that we can continue to do the good work that we do. With artificial intelligence, that is a very interesting. I think there's a lot of possibilities there, but with the risks and concerns that we have, we're also seeing it being used for good and for bad. The other thing that is probably keeping me up at night, not so much keeping me up at night, but it is a thing that I am very concerned about, is the use of finfluencers. It's not something that we've have talked about as much before, but finfluencers are, really reaching a demographic and younger set of investors who get most of their investment advice off of social media. And we need to be aware that, that's where they're getting it. We need to be meeting them, I think, where they are. But also, we need to be aware that the kind of advice that they're getting off of influence can be quite questionable. And so just really considering, how do we reach that demographic? How do we reach out to people who may be interested in learning more about investing? Because that's a great thing. We do want to get people interested in investing for the future, but we also don't want to treat it like it's just gambling. We need to treat it, seriously and get them good information.
Mm-hmm. I have some late 20-somethings in my family, and they really got into that whole, I can invest and just, do my whatever I want to do. I'm like, whoa, wait a minute. There's some education you should look at first. Mary Ellen, my kids do. I'm sure we're not the only two. So I'm going to put you on the spot real quick.
Okay.
I didn't talk to you about this. So what is the best advice you've ever given or received?
The best advice I've ever given or received. That is just go for it. Is usually some of the things that I've been scared to try. Somebody's like, well, that's a stupid reason. If fear's not the reason to not try something, you should go and just go for it. That's, I guess, career wise. But some of the best advice I have ever received, that's a hard one. But I'll have to think about that. Career-wise, I also tell people, remember your soft skills. Analytics is really great, but it's more frustrating than anything to be in a room and not be able to convince somebody that you're right.
Yes. I've been there. I know I'm right. I just can't articulate
Can't
it.
tell you why I'm right.
Just trust me. So before we close, do you have any final thoughts or highlights you want to share about your year as NASA president?
It's been just incredible. I know that I've been so proud to have worked on behalf of the state securities regulators and the provincial and territorial regulators of Canada and Mexico. It's just been a complete honor. It's one that I couldn't have done without the support of my staff and my family, and also the NASA corporate office. I would also just encourage people to look at NASA and the state securities regulators as a true resource. We are committed to not only helping investors, but in helping our industry and helping our small businesses grow and thrive, and work in ways that are compliant. So if you have questions, reach out, look at the NASA website. You can find all of our contact information available there. So really I would highly encourage everyone just to go there, take a look. These people are doing incredible work every day on behalf of you, on behalf of our investors, on behalf of your clients. And I just can't say how proud I have been to be able to have been in service to them for the past year.
That's awesome. Thank you for that. I just want to highlight that thanks to the efforts of Deb Fabrits with Wisconsin, this year's SILA conference will have the most state securities regulators that we've had to date. So thank you, Deb. I think you're out there on here. And I want to close by thanking you so much and congratulating you on such a wonderful year as NASA president. And look forward to seeing if you could beat Borg on the president.
Probably not, but thank you.
Take care, everyone.
All right.
Have a wonderful day.
Claire and Margie, thank you so much for sharing.